much higher than hand counting, and the size of the error was much higher than in hand counting, and the proof is here. I don't know what impact this will play as we go forward for November, but we have this lawsuit, the National Clean Election lawsuit, and this will be exhibit number A. In any event, over the years, there's been 45 federal judicial decisions, and you can get a link to all of those in cases that I brought in defense of the federal Constitution. Right to petition, the profound constitutional solution. No doubt about it in our minds. Here is people are familiar with the Bill of Rights, but not everybody's familiar with the preamble of the Bill of Rights. This is the preamble. The conventions of a number of the states, having at the time of their adopting the Constitution, expressed a desire in order to prevent misconstruction or abuse of its powers that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the beneficent ends of its institution. This is the First Amendment. In my opinion, the most important sentence in the entire Constitution is this sentence. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. That's freedom number one, guaranteed by the First Amendment. Or abridging the freedom of speech, the second of the 5 freedoms guaranteed by the First Amendment. Or of the press, the third. Or of the right of the people to peaceably assemble, as we're doing here today, to criticize the government or whatever. That's the 4th freedom guaranteed by the First Amendment. And to petition the government for a redress of grievances. That's the 5th freedom guaranteed by the First Amendment. The first 4 have been the subject matter of lots of lawsuits. The full contours of the meaning of those 4 freedoms have been pretty well defined by now. That last freedom, the government for the petition for redress, never been declared. The meaning of that has never been declared by any court in all these years. It is the accountability clause, as we'll see.
Well, has it now?
What?
It has now, though, right?
Not yet.
Also,
The Supreme Court, when they decline to hear a case, it's well understood. No comment. We don't know about the merits of this. We're just not going to hear it.
okay.
Now, the D.C. Circuit has said, at least in that circuit, if you were in D.C., not in the Second Circuit, First Circuit, or any of the 11 circuits, they haven't spoken. Okay, but the D.C. Circuit said they're bound by the Supreme Court decision of these 2 earlier cases that have nothing to do with this, But nonetheless, they're bound by that. And the government doesn't have to respond, and of course you can't retain your money if in any event. So that's the language of the First Amendment. The Ninth Amendment comes into play. It's kind of like an insurance amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So we, in our case, we stand on the First and the Ninth Amendment. We couple them up, okay? The Declaration of Independence, just how important is the right to petition? Let's take a look at the Declaration of Independence. The Declaration of Independence, it starts out very, very important. We all have certain unalienable rights that we are endowed by the Creator. By the Creator. By nature's God. Divine providence. These are words you find in here. The rights don't come from the government. The government can't take them away. You have them simply because you took your first breath. It's a natural human right. All of these rights that are enumerated in here, and all of those that we don't even know we have, according to the Ninth Amendment, until the issue arises. Like now, we have a right to a response. Where does it say we don't? That's under the. If we don't have it under the First Amendment right to petition, we certainly have it under the Ninth. We ask the government to answer questions they should answer. That's a natural right. So anyway, the Declaration of Independence starts out with that, and then it goes on and says, we really do owe it to the world to tell them why we're doing this, why we're separating. So you find that, and then you find in the Declaration, the bulk of the document begins with these paragraphs here, the statement of grievances. Usually they begin with the word he or they, meaning the Parliament or whatever. But these this goes on in the Constitution, on the Declaration. The bulk of the Declaration of Independence is a listing of the grievances that the colonists had against the most powerful government on the earth. A government that ruled the people here for 150 years. Not everybody appreciates that. That government was in control here for 150 years. This was not a government that just sprung up, and we didn't like it, so we got rid of it. This was institutionalized. Most powerful Navy and Army, at the time. And so here's a listing of the grievances. So it goes on and on, and on and on. I mean, you read these and you study them and you say, well, gee, sounds like some of these problems today. Not all of them, but we're getting there. Taxes on us without our consent, that's a good one. In many cases, the benefits of trial by jury, they certainly deprive us of that. You saw Aaron's movie. They decide what the law is. I was there at Dick Simcannon's trial. Dick Simcannon, the man who was charged with not withholding and not filing his taxes and so on. And at the end of that trial, I was there, the jury sent a note out to the judge. The jury said, Judge, what law did he violate? And so the judge cites from the indictment. And what does the indictment say? It quotes a penalty statute. If you're required to withhold and you don't, you can be penalized. So the judge cites from the indictment, quotes from the indictment, which is a penalty statute. And so the jury sent another note out and says, do we have to look through all 9,000 pages of the Internal Revenue Code to find the law that he violated? And the judge writes back, no, you can take my word for it. And the jury says, oh, okay, guilty.
Oh my God.
That is what happened to Dick Simcannon. That's exactly what happened to Dick Simcannon. Anyway, so these are all the listing of grievances, right? Look at this. Now, see this paragraph that says, in every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. A prince whose character is thus marked by every act which may define a tyrant is unfit to rule a free people. This is known by the scholars as the capstone grievance. It's the grievance that capped all the others. We got all these grievances and we petitioned. And our repeated petitions have been met with repeated injury. What's an injury? The Supreme Court decided not to hear the case. That's an injury to us as a free people. Lower court decisions that cite other cases that have nothing to do with ours. That's an injury. The executive and legislative branch is not responding. That's an injury. So our repeated petitions have been met with repeated injuries. And so it goes on and says, okay, this is the straw that broke the camel's back. The fact that a ruler that doesn't listen to the people, that ignores the people, is unfit to rule a free people. And so therefore, we're separating, we're out of here. I mean, basically what he says. You don't like it, come get us. I mean, that's the Declaration of Independence. Where else do we find reference to the right to petition? Hey, it goes all the way back to the Magna Carta. The year 1215. What's going on in 1215? We have monarchies. What's a monarch? It's a representative of God on earth. Can do no wrong. You can't sue him. Whatever he says goes. He wants to string all of you up. You're up. You're strung up. You're lynched. Absolute power. So what happened in 1215? The barons. And where are the barons today? Where are the barons today?
Right here.
But the barons, these were the accomplished people of the day, right? They confronted the king and the people behind them at a field in Runnymede. And the king signed the Magna Carta. The cradle of liberty is the Magna Carta. What is the Section 61 of the Magna Carta say? If we, the monarchy, our Chief Justice, our officials, or any of our servants offend in any respect against any man, if we trample on any of your natural rights, or transgress any of the articles of the peace or of this security, and the offense is made known to 4 of the said 25 barons, they shall come to us, or in our absence from the kingdom, to the Chief Justice, to declare it and claim immediate redress. If we, in our absence abroad, or in our absence abroad, the Chief Justice, make no redress within 40 days, if we don't remedy the problem in 40 days, or at least respond to the petition in 40 days, reckoning from the day on which the offense was declared to us, or to him, the 4 barons shall refer the matter to the rest of the 25 barons, who may distrain upon and assail us in every way possible, whatever means necessary, whatever means the people decide. And what will they do? They shall assail on us in every way possible with the support of the whole community of the land by seizing our castles, lands, possessions, or anything else saving only our own person and those of the Queen and our children until they have secured such redress as they have determined upon. Having secured the redress, they may then resume their normal obedience to us. You have the right, the legal right, to take everything we have, our castles, our lands, everything except my life, the life of the Queen, and the life of the children, if we don't respond to your petitions for redress in 40 days. From that moment on, in England, the petition was followed. I mean, they kept petitioning, and it was recognized that the government had to respond. And those carried forward to our land. That principle, the meaning of the right to petition, carried forward as those people came over and settled here from England. And here we have in 1774, the Continental Congress is sitting in Philadelphia. The Continental Congress, we don't have a real Congress yet, right? It's not 1787. We haven't adopted the Constitution, right? We don't have the Bill of Rights yet, right? This is just the Continental Congress. This is just the people who adopted the Declaration of Independence. I mean, so much for relevancy. They adopted the Declaration of Independence, and sitting as the Continental Congress in Philadelphia in 1774, they passed an act unanimously. And in the act, they're talking about the great rights, our grand rights. And in the act, they say, look at down below there. Second sentence in the last paragraph. If money is wanted by rulers who have in any manner oppressed the people, they may retain it until their grievances are redressed, and thus peaceably procure relief without trusting to the despised petitions or disturbing the public tranquility. This is an act, the full act is on the PDF here. The purpose of the act was to send it to the inhabitants of Quebec in an effort to encourage the Canadians to join our revolution. And in that act, they're talking about the great rights. Our great rights. And in talking about the first of the great rights, the right to government based upon the consent of the people, they said this, quote, if money is wanted by rulers who have in any manner oppressed the people, they may retain it until their grievances are redressed, and thus peaceably procure relief. It's a peaceful solution to the problem. You don't have to use force to take the castles or whatever. And thus peaceably procure relief without trusting to despised petitions. The founders knew that government despises petitions for redress of grievances. They don't like opposition from any quarter. So we don't have to trust to the despised petitions, and we can retain our money and as a solution to the problem, procuring relief without disturbing the public tranquility. From the mouths of the framers. These are the founders. Jefferson said it so there is that sentence out of the 1774 Act. And Jefferson said it this way. Jefferson was not a great public speaker, but he could really write, very eloquent. And what he said was, The privilege of giving or withholding our money is an important barrier against the undue exertion of prerogative, which, if left altogether without control, may be exercised to our great oppression. And all history shows... Is that mine? I thought I turned mine off.
Guys, turn yourself in, please.
Yeah.
Everybody, please turn yourself in.
There's nothing else more
Okay,
important in
all
our
right.
lives going on than what we're learning now.
All right, so Jefferson said, let me start again, the privilege of giving or withholding our money, giving it or withholding it, it's a privilege, is an important barrier. The ability to give and withhold is an important barrier against the undue exertion or prerogative, which, if left altogether without control, may be exercised to our great oppression. And all history has shown how efficacious its intercession for redress of grievances and establishment of rights, and how improvident would be the surrender of so powerful a mediator. Never give up your ability to give and retain your money. It's the only way, to get to keep the government within the boundaries, of that we, the people, have set around their power.
Is that a defense of a crime right there, isn't it?
What's that?
You cannot take a right and convert it to a crime.
You cannot take a constitutional right and convert it to a crime. Absolutely, right. You cannot do that. Second, listen, Michael Bednarik, interesting fellow. I was talking in Austin a year or so ago. So he was there as a guest. We were doing live webcasts on a traveling road show. And Michael Bednarik said, I got a great idea for a bumper sticker. I said, what's that, Michael? He said, if the First Amendment doesn't work, the Second Amendment will. It's a great bumper sticker. But anyway, the founders, clearly, it's there as a peaceful solution to these problems. I mean, what do we do if the government just starts doing whatever it wants to do? Saying the solution to your problems is one more than half the number of people voting in precincts and in the halls of Congress. That's a democracy. If the solution to these problems is one more than half the number of people voting in our precincts on election day, on primary day, or in the halls of Congress, or in your state legislature, then that's basically a democracy. That's majority rule. And our founders specifically eschewed to spit that out as not for us. No way. We have our rights are individual rights. Doesn't matter what the rest of society feels about the Second Amendment or the First Amendment or war or taxes. Doesn't matter. We have a right to a government that does not apply the armed forces of the United States and hostilities overseas without a declaration of war. That's an individual right. We have a right to a government that does not impose a direct unapportioned tax on our labor. That's an individual right. It doesn't matter what the rest of society knows or feels about those rights. The New Hampshire Constitution, I bring this up. This is interesting. Government being instituted for the common benefit, protection, and security of the whole community, and not for the private interest or emolument of any one man, family, or class of men. Therefore, whenever the ends of government are perverted and public liberty manifestly endangered, and all other means of redress are ineffectual, the people may and of right ought to reform the old or establish a new government. The doctrine of non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. And this is Article 10 of the New Hampshire Constitution. The title of this article is The Right of Revolution. Yes?
Does that basically give them the right to secede from the Union?
It gives them the right of revolution. This is not the time to get into whether or not the South was right, or any of those states in seceding. There are those who, and I'm included now, I didn't learn this as a child, I've learned it since. They had a right to secede. And it would have made a big difference I think, in the future, a beneficial difference in the future of the country. But nonetheless, that's what it says. All other means of redress are ineffectual. We tried everything, nothing works. They have the right to throw off the government and establish a new government. That's what the Declaration of Independence says, right? All right. This is the capstone grievance again from the Declaration of Independence. In every stage of these oppressions, we petition for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. A prince whose character is thus marked by every act which may define a tyrant is thus unfit to be the ruler of a free people, period. In our research of this issue, we learned that there were these law review articles written by prominent law school professors. None before 1986 and none since. And these are all available on our website. They're not available through this PowerPoint, but they are on the website. I strongly urge that you read two of them, the Vestigial Constitution by Gregory Mark at Fordham and the Bill of Rights as a Constitution by Akil Amar at Yale. Here, and I urge you to read those because they are a wonderful history of the right to petition, a detailed, thorough history of the right to petition. And you learn, for instance, that until the 1830s, government, whether it was your congressman, or there was Congress, or your state legislature, your county, would never have entertained the notion of not responding to a petition for redress of grievances. Every petition for redress of grievance was submitted to a committee, even at the federal level. And you always got an answer. Every Wednesday, Congress dealt with petitions for redress of grievances. What happened? You find out, in reviewing history, you find out about the gag rule. In the 1830s, 1836, Congress, the Southern congressmen prevailed. They were fed up with the petitions from the abolitionists about slavery, and they passed a rule in the House, in the Senate, saying any more of these petitions from abolitionists on this subject are going to be permanently tabled. First time government ever went on the record saying we don't have to listen or respond to the people. And it took John Quincy Adams, you learn, 8 years to repeal that rule. But the damage had been done, and it's been downhill ever since. It's become the forgotten right until now. So I urge you to read those, and that's part of our research. Then we prepared the Iraq Resolution, the Federal Reserve System, one on the Federal Reserve, one on the USA Patriot Act, one on the income tax. These were all served, which gave rise to the lawsuit, the right to petition lawsuit that the Supreme Court just said they didn't want to hear. And there have been others that we have prepared. Obviously, there's a problem in the country. It's emotional. There's a problem with illegal immigration, undocumented aliens. Look, I don't know whether, what the answer to the issue is or whether it's right or wrong. I just look at the Constitution. What does the Constitution say? Article 2 of the Constitution deals with the presidency, with the president, the executive branch. And in there, it says the president shall, take an oath to defend the Constitution, and there's this clause that's that he will faithfully execute the laws. It's the faithfully execute clause. Okay. We have extensive set of laws on the books passed by Congress that are not being enforced, having to do with immigration and naturalization that are not being enforced. Neither party wants to offend a large block of votes, the Latino vote. I'm sorry. If you don't like the laws, repeal them. But if they're there, the president's job is to enforce them. So there's a petition for redress of that grievance. The North American Union, extensive petition for redress of grievances regarding the developing North American Union. It's unconstitutional. The right to keep and bear arms. There's a lot of gun control laws that are unconstitutional. It's also unconstitutional for the states not to have well-regulated militias. If you're familiar with Ed Vieira's recent work, the Constitutional Homeland Security. And one on foreign policy. Ron Paul was right. It is blowback. The 9/11 attack, Ron used the right words. Those weren't his words. Those were the words of a guy named Michael Sherrar. Michael Sherrar was on the Osama bin Laden desk at the CIA and knew all about Osama bin Laden for years. And he was the CIA agent that wrote a book called imperial hubris. And at the time he wrote it, the CIA, he had to be, when interviewed, he had to be in silhouette. He couldn't be identified. But now the CIA has allowed him to out himself. And he has. It's Michael Sherrar. And in his book, he does a pretty good job of saying, look, these people are not upset with us because of who we are. It's because of what we do over there. And that's Ron Point's point. It's our foreign policy. It's our CIA coup of putting the Shah of Iran in place and throwing out the democratically elected government that was there before the Shah. A very oppressive regime oppresses the people in Iran. All the regimes over there do. They oppress their people, whether it's the Saudis. And we shore those governments up. We keep them in power. There's a lot of oppression over there. Well, the people, this is Ron Points. He doesn't say it in these terms, but this is basically what he's saying. The people over there, like people here, we did it, they're constantly like this with their governments because the governments are oppressive in all of these countries. And so as President Reagan said, government is the enemy of freedom. So people see the government as the enemy, you know, and pretty soon they see that we're a friend of their enemy. Well, that makes us their enemy. And so they begin to direct their hostilities towards us. Well, what has that produced in this country? A war on terror. What has the war on terror produced? A police state with surveillance cameras, opening your mail and opening your, and listening to your phone and everything else, all in the name of, you know, watch V for Vendetta. That's the message there, okay? And so, look, I see these things. We're observant. We're saying, well, what's the constitutional issue here? So we just rummage through the Constitution, and what do we find? We find the General Welfare Clause. Where is that? That's up front of the enumerated powers for Congress. It says, Congress, you get all these powers. You'll use them to defend the country and for the general welfare of the country. Wait a minute. What about all this foreign aid we're giving to shore up these governments over there? Building these military bases. Authorizing money to build Osama bin Laden, as part of our research for the petition for redress, look, I'm not against war. I'm not against taxes. I'm just for the Constitution, right? So as part of our constitutional analysis here, we reviewed history pretty good. And we read everything Osama bin Laden has had to say publicly. There's books out on this. All of his utterances in his messages, speeches, and so forth. You can read them, right? Of course, we read not on his side of things, but on the other side as well. And what do we find, for instance? That in Gulf War I, Osama bin Laden, as a member of the royal family, remember, we trained him and supported him in his fight against the Russians in Afghanistan. But nonetheless, come 1990, we're going into, because Saddam Hussein has invaded Kuwait, now we're going in there, right? Well, we want to build a military base in the Saudi peninsula, in the land of Mecca, in the land of Muhammad. So Osama bin Laden, a very religious man, he says to the royal family, don't let foreigners do this. Don't let America do this. And, you know, he was told by the royal family, by us, don't worry, it'll be temporary. We'll be out of there after the war. Well, we stayed. And this upset him. I'm not defending Osama bin Laden or what he's done, believe me. But it's, Ron Paul's right, it's blowback. It's what we do. We're building bases and, you know, and invading countries and so forth. And these are powers, enumerated powers that are being exercised, but is it in the general welfare? Is this in the national interest? So there's a petition for redress of grievances, raising questions and asking for answers to questions, that's all. To us, the Constitution is not a menu. It's not a menu. We can't pick and choose. Just because we favor, you know, the Saudi, you know, they buy a lot of weapons, and boy, they're good people, and they're keeping this religion, you know, at bay, or whatever it is. We can't decide which part of the Constitution we like and which part we're going to defend and which part we don't like. So we have a petition for redress of grievances there. We can open up any one of these if anybody wants to see what one of these petitions for redress of grievances actually looks like. Why don't we just do that? Why don't we go back to the Federal Reserve? That's one of Ron Paul's favorite ones. Or the USA, or the Iraq resolution. But what we do here with these petitions is there's a few whereases. Whoops, sorry. And then we get down to asking questions, tough questions, that bring us back to specific clauses of the Constitution and the law. And we treat these petitions for redress as depositions. Those of you who have been in lawsuits, you know what a deposition is. The two sides in a lawsuit are allowed to